Welcome back. Today, we're turning to a case currently on appeal, United States versus Maxwell. When a party loses their case in federal district court, the next step is an appeal to the circuit court, also known as the Federal Court of Appeals. If that appeal is unsuccessful, the losing party can request a review by Supreme Court by filing a petition for certiorari, and that's exactly what Maxwell has done. This video covers Ghislaine Maxwell's petition, DOJ opposition, and the relevant case law and filings tied to both, along with any photos, which I'll overlay on screen for context. Because I can't promote many of these videos, I rely on viewers like you to keep them visible. If you appreciate straightforward, sourced breakdown without noise, go ahead and like, subscribe, and share. Now let's jump in. This is a petition dated April 10th, 2025 for a writ of certiorari in the Supreme Court of the United States. The petitioner is Ghislaine Maxwell, or Sealed Defendant 1. The respondent is the USA. Maxwell is requesting review of a Second Circuit decision. The question they're presenting to the Supreme Court is first framed by Maxwell by citing case law and acknowledging varied opinions in circuit courts regarding pleas and non-prosecution agreements. That said, the question presented here is, under Santabello and common principles of contract interpretation, does a promise on behalf of the United States or the government that is made by a United States attorney in one district bind federal prosecutors in other districts? These pages establish the background of the petition, framing the case history and the jurisdictional footing for Maxwell's Supreme Court request. Statement of the case. Despite a non-prosecution agreement, also known as an NPA, explicitly shielding Epstein's co-conspirators, the U.S. prosecuted Maxwell anyway. Maxwell now serves a 20-year sentence due to conflicting interpretations of the same agreement, and SCOTUS should step in. Procedural background. A. Entry of the NPA. In 2007, Epstein struck a deal with Southern Florida U.S. Attorney Office, or USAO. He'd plead guilty in Florida, serve time in Florida, and pay restitution. In return, the U.S. agreed not to prosecute him in Florida. The co-conspirator clause was negotiated alongside Epstein's protection from prosecution in Florida's Southern District. Unlike previous versions, this version did not contain geographic limitations within the U.S. The NPA stated it was not binding on the state attorney's office in Florida, but lacked a similar statement for the USAO. Epstein upheld his obligations under the NPA after pleading guilty in June of 2008. B relates to criminal proceedings in district court, and in July 2019, Epstein was indicted on trafficking and related charges in the SVNY. The NPA did not impede on the indictment, as Epstein's protection was limited to charges in Florida, and Epstein died a month later, while incarcerated. Over 1 year after Epstein's death, Maxwell was indicted in New York for similar crimes, initially dated pre-2000, likely in an effort to skirt the NPA's timeframe. Maxwell's 2021 charges duplicated conduct resolved by Epstein's 2007 deal, including claims from a complainant whose allegations had already been dropped under the NPA. Maxwell moved to dismiss, pointing to the NPA's plain language. Simply put, if Epstein met his terms, the United States would not charge any co-conspirators, including her. This protection applied nationwide. Maxwell requested a hearing and discovery to establish this very thing, but her motion was denied. The court declined discovery, but ordered the government to share in any evidence supporting her NPA-based defense. In response, prosecutors admitted they hadn't searched relevant emails or used targeted NPA terms and had no plans to review materials from Florida's prosecutors or the OPR investigation, leaving key internal communications untouched. The court ruled Maxwell could invoke the NPA, but she wasn't immune in New York. Her trial proceeded, and the jury found her guilty, including on count 6. She serves a 20-year sentence. In 2019, an office within the DOJ investigated Epstein's plea deal. While the report didn't resolve whether the co-conspirator clause applied beyond Florida, government witnesses stated that it conferred transactional immunity. OPR also found no policy barring federal prosecutors from granting such immunity to third parties. C. On appeal to the Second Circuit, Maxwell argued that NPA's plain language barred her prosecution in New York. The Second Circuit disagreed, citing case law that a local precedent holding plea agreements bind only in the district where they're made, unless broader intent is explicit. Even though the NPA had no limiting language and the government witnesses said it conferred nationwide immunity, the court ruled it wasn't meant to bind other districts, and it upheld her conviction. Maxwell moved for a rehearing of the full judge panel, which was denied. Reasons for the petition. This case exposes a deep divide. The term, quote, United States in the plea seems to mean one thing in New Jersey and another thing in New York. Defendants who plead guilty resolve all liability may still face prosecution, simply depending on which circuit they're in. This court should resolve this conflict for the sake of consistency. 1. Circuits are split. Case law established in the Supreme Court determined that a prosecutor's promise in a plea binds all prosecutors, stating specifically that, quote, the circumstances will vary, but a constant factor is that when a plea rests in any significant degree on a promise or agreement of the prosecutor so that it can be said to be part of the inducement or consideration, such promise must be fulfilled. In a separate case, the Supreme Court ruled that the prosecutor's office is an entity, and as such, it is the spokesperson for the government. A promise made by one attorney must be attributed for those purposes to the government. Despite Supreme Court precedent requiring prosecutors to honor plea deal promises, the Second Court, who heard Maxwell's appeal, and another court, restricts enforcement to local districts unless broader intent is explicitly stated. This is in conflict with 4 other courts, creating a circuit split with nationwide ramifications. A nationwide circuit split creates ambiguity and varies interpretation, resulting in a lack of clarity as to whether a guilty plea resolves liability nationally or just locally. Maxwell presents a clean opportunity for the Supreme Court to resolve this divide. A. As mentioned, 4 courts faithfully applied Santabello's instruction. Specifically, the Third Circuit saw the inconsistency between courts and held that when a U.S. attorney makes a promise on behalf of the United States, it binds all federal prosecutors nationwide, absent clear limitations. The Fourth Circuit was actually first to hold that a promise in one district binds to all others, while the Third Circuit highlighted contract principles and rejected the idea that U.S. attorneys operate as isolated, quote, fiefdoms. The Fourth Circuit emphasized national consistency and public trust. The Eighth Circuit similarly came to the same conclusion, finding in one case that a promise made extends to other districts, and in a second case, that the United States refers to the entirety of the U.S. government and all its agencies. The Ninth Circuit aligns with the others on nationwide binding, but uniquely grounds its reasonings in agency theory and default enforceability across all departments and districts. B. The Second and Seventh Circuits apply opposite presumptions regarding enforcement of promises made on behalf of, quote, the United States or, quote, the government. The Second Circuit in Maxwell, this very case, requires explicit language showing broader intent, holding that the United States, in a plea deal, binds only the district where it was entered. The Seventh Circuit limits a prosecutor's agreement to the local office, rejecting nationwide binding unless explicitly stated, even in related agency contexts. 2. The Second Circuit adopted its own interpretive approach, but the petition argues that it shouldn't because lower courts can't redefine federal laws in ways that can conflict with Supreme Court precedent and settled contract principles. A. Both Unnamed and Maxwell are wrongly decided because the petition argues, under Santabello and Giglio, when a defendant pleads guilty in reliance on a government promise, they're entitled to finality. The legal consequences are resolved, and prosecution elsewhere for the same conduct violates that promise. B. Maxwell argues that plea agreements follow standard contract law, where federal promises bind nationwide unless limited. Courts in 4 districts agree, and case law plus Scalia and Garner's canons back that view. The Second Circuit decision defies this precedent, misreading the term United States, inverting fairness principles, and creating a geographic loophole in federal accountability. Placement of co-conspirator in the NPA was moved from one section to another because that very section was not limited to any district. As every circuit recognizes, ambiguities in pleas goes in favor of the defendant and not against them. C. the available evidence suggests that the NPA was meant to bind the Southern District of New York. First, the petition says Epstein's denial clearly limited his immunity to Florida, but it didn't add any limits for co-conspirators, suggesting that their protection wasn't meant to be restricted. When a contract spells out one boundary and stays silent on another, that silence usually means that the rest is included, so Maxwell shouldn't be prosecuted in New York because the agreement was meant to apply nationwide. Second, negotiation history reinforces this. Early drafts confined co-conspirator immunity to Florida, but final language dropped that restriction and referred to only the United States. Government witnesses cited in DOJ's internal report affirmed that this clause conferred transactional immunity. Crucially, as the petition emphasizes, those were the only witnesses consulted, underscoring the lack of balance in that investigation. Third, the petition challenges the Second Circuit's reliance on the Judiciary Act and the DOJ Policy Manual. While the Act says that prosecutors work within their districts, the Justice Manual clarifies that if they don't want an agreement to bind other districts, they must say so explicitly. No such limitation was included here, meaning that silence supports nationwide accountability. Fourth, the NPA's recitals point to a broad global resolution of Epstein's state and federal liability. It refers to the interests of the United States, not Florida or a specific district, signaling that the agreement was crafted to resolve exposure across jurisdictions. These elements show the agreement was not confined to Florida, it barred prosecution in New York as well. 3. Maxwell's petition asserts that this case is an ideal vehicle for resolving a long-standing circuit split over whether plea agreements made by one USAO bind others nationwide. This agreement here promised that the United States would not prosecute Epstein's co-conspirators, yet Maxwell was prosecuted in New York. The only real question, the petition argues, is whether that promise applied only to Florida or to federal prosecutors across the country, because this issue is divided with federal courts and implicates the integrity of the plea bargaining itself. The petition says it's right for the Supreme Court to review. And in conclusion, the court should grant certiorari to resolve this split and uphold federal plea integrity. With Maxwell's claims stated, we now turn to the government's brief in opposition. The government frames the issue as follows. Did the federal prosecutor in New York violate a prior NPA when charging Maxwell with trafficking of a minor? Moving now to the statement, Maxwell was convicted of 3 federal trafficking charges in New York, sentenced 240 months in prison, and her conviction was upheld by the Second Circuit on appeal. Section 1 discusses the background of the Epstein scheme and the Florida agreement. From the mid-1990s to the early 2000s, Ghislaine Maxwell assisted Jeffrey Epstein in exploiting underage girls. They targeted teens, built trust through gifts, and introduced abuse under the guise of massages. Victims were paid and some recruited others. The abuse occurred in Florida and New York. After local police investigated in 2005, the case was referred to the FBI. Federal prosecutors in Florida prepared a 60-count indictment, but instead struck a deal. Epstein would plead guilty to state charges, and in return, federal prosecution would be deferred. The agreement, signed in 2007, included a clause that if Epstein fulfilled the terms, the United States would not prosecute certain unnamed co-conspirators. 4 of his assistants were listed. Maxwell was not named. The DOJ later called the co-conspirator clause highly unusual. Prosecutors admitted that they hadn't considered that Epstein might be shielding others, and speculated the clause may have been to protect assistants who were also victimized. Throughout the agreement, references to the United States were used, interchangeably with U.S. Attorney and U.S. Attorney's Office. DOJ policy was clear. No district can bind another without written approval, and no such approval was given. Epstein served about a year in a minimum security facility, but in 2019, the New York office indicted him on trafficking charges. Florida's deal did not protect him. 2 is the government's framing of Maxwell's indictment and trial. And as we've discussed, in 2020, Maxwell was indicted for 6 charges of child exploitation and 2 perjury counts related to Epstein's scheme. Maxwell tried to dismiss the indictment, arguing Epstein's Florida agreement protected her as his co-conspirator. The court rejected her claim. It held the deal only applied to Florida's prosecutors, and even if it extended further, most of her conduct wasn't covered. Maxwell went to trial in 2021. The jury convicted her on 5 counts, and she was sentenced to 20 years in prison. Her attempt to invoke Epstein's plea deal failed. 3, as we've discussed, the circuit court ruled against her appeal. Citing longstanding precedent, the court held that legal agreements like Epstein's only applied to the district that they were signed, unless there's clear evidence that they were meant to restrict other offices. In this case, there wasn't. Every phrase in the deal pointed to Florida's specific limits. The court also found no sign that prosecutors in New York or DOJ leadership ever reviewed or approved the agreement as applying beyond Florida. As under federal law and longstanding DOJ policy, each USAO is district-bound by default. Maxwell's attempt to use the Epstein deal as a shield simply didn't hold up. In their argument, the government argues that Maxwell's interpretation of the NPA wouldn't hold up in any appeals court, let alone the Second Circuit, and that the case isn't suitable for the Supreme Court to review because no constitutional questions are raised, and this is simply a repeat of an earlier case. So more on that now. Number 1, Epstein's Florida deal didn't block charges in New York. A. The government's key point is straightforward. The agreement reached in Florida didn't protect Maxwell from prosecution elsewhere. NPAs are treated like contracts. They're interpreted based on their full context, not isolated phrases. The clause mentioning co-conspirators used the term, quote, the United States, unquote. But the government argues that this was interchangeable with, quote, U.S. Attorney or, quote, U.S. Attorney's Office, referring specifically to the Florida prosecutors who signed it. There's no indication that the agreement bound any other office federally. The DOJ policy was firm. One district can't create a deal that binds another without formal approval. No such approval was sought or given. Maxwell wasn't named, wasn't known to prosecutors at the time, and the protection offered in the agreement was limited to actions, quote, in this district, meaning Florida. Even if the language seemed vague, the surrounding evidence made it clear the clause didn't reach beyond Florida. B. Maxwell's arguments are not substantiated. Maxwell claims prosecutors should be held to the promises and that any unclear language should be interpreted in her favor. But the government says those points assume the agreement was ambiguous, when in fact it wasn't. She highlights that the co-conspirator clause didn't contain the same limiting terms as the other parts of Epstein's deal, but legal rules around implied meaning don't apply when the document structure doesn't support that reading. Here, the wording lacked the kind of symmetry needed to show broader intent. She also points to the early drafts that narrowed co-conspirator protections to Florida specifically, but the DOJ notes that none of the people involved saw those versions as creating geographic differences. In fact, a senior prosecutor later stated the deal was not global and that other districts remained free to prosecute. Finally, Maxwell links the co-conspirator clause to sections about civil suits involving victims, but those references only reinforce that the deal was meant for Florida, like the part saying Epstein wouldn't contest jurisdiction there. Nothing in the agreement extended protections to anyone outside that district, least of all Maxwell. 2. Maxwell argues that federal appeals courts disagree on how terms like the United States or the government should be interpreted in legal agreements. It's true that some circuits treat such terms as applying only to the prosecutors who sign the agreement, unless broader intent is clearly shown. Others assume the terms apply more widely, unless limited in the text. The government points out the agreements clearly show whether they're district-specific. Courts rely on actual wording and not theoretical disputes. In Maxwell's case, both trial and appellate courts agreed. Nothing in the Florida deal suggested other prosecutors were bound. And even if the United States, quote unquote, could have meant more, the evidence and the wording proved it didn't. The Supreme Court has turned away similar cases before, and this one doesn't present anything new or unsettled. There's no need for further review. 3. Maxwell simply does not have the right to enforce Epstein's deal. Even setting the legal arguments aside, the government argues this case still doesn't qualify for Supreme Court review because Maxwell wasn't a party to Epstein's agreement. She wasn't named in the deal, wasn't part of the negotiations, and wasn't known to prosecutors when the agreement was even signed. And in contract law, someone who wasn't involved can only benefit if the original parties clearly intended to protect them, which it didn't appear to here. Even if the Florida prosecutors had tried to offer her protection, they didn't have the authority to bind other federal offices. DOJ policy required formal approval for each district involved, and that never occurred. Maxwell can't rely on general agency rules or legal shortcuts like implied promises. Those don't apply to agreements with the federal government. At most, Maxwell was an incidental third party, not someone with enforceable rights under Epstein's NPA. Conclusion: the petition should be denied. Thanks so much for watching this two-part series on Epstein and Maxwell. If you found it informative, please like, subscribe, and share. It really helps support clear, source-based coverage. I'll be back soon with more cases worth unpacking. In the meantime, stay safe.